Definitions of residence for tax purposes vary considerably from jurisdiction to jurisdiction. For individuals, physical presence in a jurisdiction is the main factor. Some jurisdictions also determine residency of an individual by reference to a variety of other factors, such as the ownership of a home or availability of accommodation, family, and financial interests. For companies, some jurisdictions determine the residence of a corporation based on its place of incorporation. Other jurisdictions determine the residence of a corporation by reference to its place of management. Some jurisdictions use both a place of incorporation test and a place of management test. Domicile is, in common law jurisdictions, a different legal concept to residence, though the two may lead to the same result. Residence as defined in double taxation treaties may be different from residence as defined for domestic tax purposes. Tax treaties generally follow the OECD Model Convention. OECD Model Convention. The OECD Model Convention provides, 1. For the purposes of this convention, the term resident of a contracting state means any person who, under the laws of that state, is liable to tax therein by reason of his domicile, residence, place of management or any other criterion of a similar nature, and also includes that state and any political subdivision or local authority thereof. This term, however, does not include any person who is liable to tax in that state in respect only of income from sources in that state or capital situated therein. 2. Where by reason of the provisions of paragraph 1 an individual is a resident of both contracting states, then his status shall be determined as follows. A. He shall be deemed to be a resident only of the state in which he has a permanent home available to him. If he has a permanent home available to him in both states, he shall be deemed to be a resident only of the state with which his personal and economic relations are closer. B. If the state in which he has his center of vital interests cannot be determined, or if he has not a permanent home available to him in either state, he shall be deemed to be a resident only of the state in which he has an habitual abode. C. If he is an habitual abode in both states or in neither of them, he shall be deemed to be a resident only of the state of which he is a national. D. If he is a national of both states or of neither of them, the competent authorities of the contracting states shall settle the question by mutual agreement. 3. Where by reason of the provisions of paragraph 1 a person other than an individual is a resident of both contracting states, then it shall be deemed to be a resident only of the state in which its place of effective management is situated. Tax residence in the United Kingdom. Tax residence in the United Kingdom for companies equals, a company is generally treated as resident in the United Kingdom for tax purposes if it is incorporated in the United Kingdom or, if the company is not incorporated in the United Kingdom, if its central management and control are exercised in the United Kingdom. Central management and control refers to the highest level of oversight, usually as exercised by the board, rather than day-to-day management. Tax residence in the United Kingdom for individuals equals, an individual who spends more than 183 days in the UK in a tax year as UK resident. Apart from that, there are no clear statutory guidelines. The question of whether someone is UK resident is a question of fact and degree, to be determined on all the circumstances of the case. The vagueness of this test has often been criticised. Viscount Sumner said in 11 VIRC, the words resident in the United Kingdom guide the subject remarkably little as to the limits within which he must pay and beyond which he is free. The legislature has, however, left the language of the Acts substantially as it was in 1801, nor can I confidently say that the decided cases have always illuminated matters. In substance persons are chargeable or exempt, as the case may be, according as they are deemed by this body of commissioners or that to be resident or the reverse, whatever resident may mean in the particular circumstances of each case. The tribunal thus provided is neither bound by the findings of other similar tribunals in other cases nor is it open to review, so long as it commits no palpable error of law, and the legislature practically transfers to it the function of imposing taxes on individuals, since it empowers them in terms so general that no one can be certainly advised in advance whether he must pay or can escape payment. Similarly, the Codification Committee concluded, An inquirer can only be told that the question whether he is resident or not is a question of fact for the commissioners, but that by the study of the effect of a large body of case law he may, emphasis added, be able to make an intelligent forecast of their decision. More recently, the Chartered Institute of Taxation concluded, the law determining whether an individual is resident in the UK is a mess. The number of days present in the UK is not a decisive factor. In one case, a foreigner who spent 5 months in the UK was held not UK resident. In the view of HMRC, someone who exceeds 90 days on a 4-year average is UK resident, but considerable emphasis is given to the fact that someone who averages less than 90 days may also be UK resident. Before 2009/10, the vagueness of the law did not seem to matter because HMRC published relatively clear guidelines in document IR20. That document has been withdrawn from 2009/10 and replaced with the much vaguer guidance in HMRC 6. HMRC currently argue that they are not bound by the terms of IR20 for years prior to 2009/10. Whether that is correct is currently the subject of litigation. It is clear that HMRC are not in any way bound by the terms of HMRC 6, which contains a very full disclaimer. Tax residents in Germany. All tax-resident individuals are taxed on their worldwide income, regardless of the source. This would include salary, dividends, etc., and from one's limited company. Generally, individuals are deemed to be tax-resident if they are physically present in Germany for more than 6 months in any one calendar year or for a consecutive period of 6 months over a calendar year end. This ruling is applied retrospectively, so presence in Germany from March 1 to November 30, for example, would make one a German tax resident and therefore subject to German tax on the worldwide income for the entire period rather than just from the beginning of the 7th month. An individual can also be deemed tax resident if they acquire an abode in Germany. This can include renting, as opposed to purchasing, a property, but only if the duration of the lease is deemed to be more than temporary. For this reason, to avoid German tax residency, short term should be taken out wherever possible. Non-resident individuals are taxed on German source income only. In the case of salary and benefits from your limited company, the source is German since the duties of the employment are being performed in Germany. However, dividends from your limited company would be from a non-German source regardless of where the dividends are received. There is, therefore, scope for tax mitigation here if one does not become a German tax resident. Tax residents in France. French tax law does not explicitly refer to tax residents. Taxpayers can either be domiciled in France or non-resident. Strictly, there is no way to avoid taxation of foreign source income without keeping non-resident status. Many treaty exemptions may apply, however. Pursuant to Article 4b of the French Tax Code, an individual is resident in France for tax purposes if they have a home or their principal place of physical presence in France. They have their professional activity in France, unless such activity is only ancillary. Or, they have the center of their economic interests in France. French courts have ruled that the principal place of physical presence test is only applicable where the home test cannot be applied. A home is to be construed as the place where the taxpayer normally lives, without any regard being given to the taxpayer's temporary stays in another country. As the home test is concerned with where the taxpayer's family ties are, this test is highly unlikely to apply to single individuals. Consequently, the principal place of physical presence test should be viewed as primarily applicable to single individuals only. Principal place of physical presence covers a wider range of situations that a basic 183-day rule would have. This is because the taxpayer's physical presence in France in a given calendar year will be tested against his presence in another country. Perpetual travelers must therefore be able to demonstrate that they have resided in a foreign country for a longer period in the relevant calendar year. Tax residents in the Russian Federation. In Russian Federation, all tax-resident individuals are taxed on their worldwide income, regardless of the source. Individuals are deemed to be tax residents if they are physically present in Russian Federation for more than 183 days during consecutive period of 12 months. The period of presence in Russian Federation is not interrupted in case individual is out of the country for less than 6 months for educational purposes or for medical treatment. Foreign servants and civil servants that were sent abroad for work purposes are deemed tax residents no matter how long they really are present in Russian Federation. See also, physical presence test, tax exile, tax haven, international taxation, tax treaty, permanent tourist. References. External links, site explaining what makes a person as tax resident, for different jurisdictions. Grant Thornton Tax Book for Expats, Deloitte Tax Guides, Taxation of Foreign Domiciliaries in UK Law.